Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague, Russell Berger, both attorneys at Offit Kurman. And today we are talking about litigation strategy and more in just the deciding when to litigate and whether it makes sense to litigate. So often we have clients that'll come to us that'll say like, oh, I've got this great case. We take a look at it. They want to sue someone for a breach of contract or whatever the issue may be. And it's a great case. It looks great. The facts look great. Oh yeah, that's you've got good merits there. It doesn't always make sense to pursue it. What are some things that people should consider when deciding whether to pursue a case, even if it looks like a slam dunk?
Yeah, so to that point, I think there's a difference between whether the case is winnable and whether the case is collectible. And ultimately, the way litigation works is it's about collecting money and it's collecting dollars for the harm that you've suffered. And I'm leaving aside for the moment the injunctive reliefs and other avenues, which are relatively rare. But if you have a contract with someone, they've breached it, they owe you money. Um, it's not worth pursuing unless you're going to get paid, even if you can win and have a paper judgment. It's not worth the paper it's printed on. So I think one of the key things that a plaintiff should do in this context is determine whether it's going to be collectible, whether the juice is going to be worth the squeeze, whether you're going to be 10th in line with judgments, whether the defendant is already in bankruptcy or it's a defunct business that you're not going to be able to get anything out of. And there can be some nuance to that. It's not just as clear and as black and white all the time. But I think it's a really good starting place is if I'm going to invest in even just filing a complaint and going through the process of getting a default judgment, is that going to be money well spent?
And these are things that people can also be thinking about even well before there's a breach. So I think it's something that folks don't think about quite as much as maybe they should when they're first entering into a contract as well, to say, all right, well, I've got great provisions in this contract. I've got attorney's fees. I've got, if they breach it, then I'm sitting pretty. It looks great. Well, if it's a business that's a fly-by-night business that doesn't really have anything, that's not going to really do much for you either. So it's something that you can actually even consider from the start when you're engaging with another business and entering into a contract and just kind of looking into them a little bit to see, like here in Maryland, we have a thing called Maryland Judiciary Case Search, where you can look a company up and see if they have lawsuits against them or they're party to cases, or if the individual owners have had cases against them, and kind of get a sense of maybe whether that's an issue. There's other research tools and stuff as well, and obviously asking around and other informal ways. And then there's ways to protect yourself as far as the way you might pay on a contract. So if it's a contract for services or it's something where you can draw out the payments, that can also help as well, because you'd rather not be sitting in a place where you have to litigate, even if you're, like I said, sitting pretty and it's a slam dunk or it looks great or the contract's really favorable to you. If you do go to litigation, it's still never the most desirable result to try to get your money.
Right. Well, and I love the suggestion of trying to get further upstream. I mean, I think that's advice we generally give in various forms here. But the more you can vet and you feel good about who you're getting into a contractual relationship with, the better. Likewise, as you said, the contractual terms, and you give the example of if you're the one paying, stretching things out over time and making sure you get what the deliverable is before you're making payment. If you're on the other side, the opposite is true. Get your money up front, get as much of it as you can, withhold the final delivery until the final payment is made, things like that, that can really go into contract negotiating on your way into this type of relationship. And along those lines, one of the other points to consider, besides the financial cost benefit of entering into litigation to try to remedy a breach of contract, is also the risk factor of, am I going to get countersued? Does this other party have something that they could point their finger back at me? Oftentimes the answer is no, and you can just move past that issue and get back to the financial considerations. But it's another consideration that I think a business ought to go through before it institutes any kind of lawsuit.
Yeah, because I think that's a great point, Russell, because also you could have a really straightforward case, but perhaps the other party files a counterclaim that's more complicated. So now you're thinking you're going to have this really straightforward collection. It's a really easy case. Maybe there's it's going to be summary judgment. You're not going to go into discovery, and it's just going to be really straightforward. And then someone sues you with something that's a little bit more complicated, fact specific, requires more investigation, those types of things. So that's a really great point, something to really consider. Well, thanks, Russell. We'll see you next time.
Thanks, Sarah.